Welcome, Andy. We're so happy to have you here. You know, our audience is pretty familiar with what a litigation partner in a big law firm does, but people probably are not very familiar with what a senior lawyer at a legal finance company does. Can you give us a thumbnail about what your work week looks like?
I basically operate in 3 silos at Burford. First, I'm a member of the 9-member commitments committee, which is essentially our investment committee, the committee that decides which matters we will finance. So I get a look at every deal that we are thinking about making a commitment to. Second, I'm, I guess you'd call it a brand ambassador, introducing law firms and companies to the legal finance landscape. And third, I'm a worker bee on individual opportunities that we're looking at and on individual cases that we have in our portfolio that may, where I may be able to add some value, often on insurance coverage cases, since that was my background in practice.
Okay, so let's turn to the substance of things. I know that I'm not as familiar with litigation finance as I should be, and a lot of other mediators may not be as familiar with litigation finance as they should be, litigation finance being a relatively new phenomenon. So let's do a little litigation finance 101, shall we? That gets our audience up to speed on just what we're talking about when we talk about litigation funding in 2022.
There's no shame in not being up the learning curve on litigation finance, even in 2022. I can relate to that as a practicing lawyer. I didn't have really any substantial exposure to legal finance in connection with the many cases I handled as a plaintiff side lawyer when I was in practice. I wish I had, would have given me a lot more options in structuring those engagements, and therefore probably would have been a big aid in developing business. But better late to the party than not invited at all for all of us. So let's talk a little bit about how legal finance works, and maybe at the same time, and maybe more important, how it doesn't work. There are some recurring major misunderstandings about the nuts and bolts of legal finance that lead people to suppose things are happening that aren't actually happening. And I think it's helpful to correct those misimpressions.
What's actually happening?
Yeah, at the most general level, what legal finance firms do is to underwrite legal risk. So what does that mean? The most common risk that we underwrite is, and the most familiar one to most people, is the risk of prosecuting a claim unsuccessfully. That is the risk of spending money to litigate a case and ending up out of pocket rather than in the money. In our most popular and common incarnation, we finance the legal fees incurred in prosecuting a claim in court or in arbitration.
So, Andy, when you say we finance legal fees, does that mean that you work with a plaintiff who wants somebody else to pay its legal bills? Or are you working with a law firm who wants you to pay it for the work it does for its client? Who's your client? Who's your counterparty when it comes to financing legal fees?
Both. Litigation funders invest both with parties and with law firms. So in the former instance, say a company has a case that it wants to pursue using its regular counsel or perhaps some other specialized counsel with expertise in the particular area involved. The company may not have the cash to pay those lawyers by the hour, or it may have the cash but prefer to be using that cash on R&D or marketing or otherwise building its business rather than paying lawyers and risking it on an uncertain litigation outcome. But suppose that company and suppose the lawyers that company wants to use aren't interested in taking the case on a contingent fee basis. So we'll fund the prosecution of the case on an hourly rate basis, although we may ask the law firm to keep a little skin in the game one way or another. So that leaves us taking on the litigation risk that the client and the lawyer both don't want by assuming the cost of prosecuting the case. In other instances, we'll have a law firm that has an opportunity to pursue a case or a group of cases on a partial or complete contingency fee basis, but doesn't have the appetite for taking on all that contingent risk itself, or it's comfortable with the level of risk, but it just doesn't have the capital on hand to litigate several big cases for the several years that big cases can take. It needs to pay the associates, pay the staff, pay the rent, hire the experts, and it just may not have the cash on hand to do all that. So in a situation like that, we'll be the law firm's risk-sharing partner, so they can offer contingency terms to their clients, but have predictable cash flow and a floor underneath the risk they're taking in pursuing those cases. As I suggest there, sometimes we'll do this on an individual case basis, but what we prefer and what the trend is toward is so-called portfolio financing, where we invest in a group of cases that a company or a firm is prosecuting, and we fund all of them. Our investment is, in those cases, is cross-collateralized across all the cases. So a loss in one doesn't necessarily mean a loss on the overall investment. And of course, by doing that, that reduces our risk and accordingly reduces the risk or the cost of our capital to the company or the firm that we are financing.
Andy, can you give some examples of the kind of portfolios of cases you're talking about? Are those mass tort cases? What kinds of cases are they?
We are a commercial litigation funder. We don't do bodily injury cases. We don't do divorce cases. We generally focus on typically on cases that involve two business entities that are going at it. Sometimes two business titans against each other. Sometimes more of a David and Goliath situation. But the areas that we frequently find ourselves in include intellectual property, patents, and so forth. Antitrust. We do a considerable amount of work in the international financial treaty arbitration space and all sorts of international commercial arbitrations, investor state arbitrations, that sort of thing, and just the entire run of commercial disputes that you see arising out of contract or business torts.
When you talk about absorbing the cost of prosecuting cases, do you finance only the lawyer's fees? Do you cover court costs, experts, all that sort of thing as well?
Yeah, we'll finance any or all of the above. So, for example, some law firms who work on contingency are happy to keep the risk that they won't recover on the time they put into a case, but they don't want to go out of pocket on expenses and costs. They don't want to pay expensive experts, litigation support vendors, and all that other stuff. So we might just finance costs for a case or portfolio of cases with a firm like that. Other firms and companies are looking to share both the risk on legal fees and on out of pockets, and we'll finance both, and sometimes we'll just finance the lawyer's fees.
So when you agree to finance a case, there's a possibility that the case will be adjudicated and will be a loser. What happens if a case is a disappointment or is lost or doesn't generate enough proceeds to pay back what you've invested in your costs or fees?
The funder bears the loss. Our investment in a case or portfolio case is not a loan. We are not a commercial lender. Our investment isn't secured by all the assets of the plaintiff or all the assets of the law firm we're doing business with. Nobody is writing personal guarantees to us. It is strictly a non-recourse financing. So the counterparty has no exposure to us in that unfortunate event, and no recovery in the case means no return to the funder, either of its investment or the premium it was hoping to receive.
Yes, so you're sort of in the situation of a typical contingent fee lawyer, right? No recovery, no fee.
And Yes, in a very general sense, the sense that it's a non-recourse transaction or relationship. The funder, like the contingent fee lawyer, bears the risk that the case is unsuccessful. You might say, and this is a metaphor I use often, you might say that what litigation finance does is take your classic contingent fee lawyer who both litigates the case and also finances it, takes the risk on it. And we cut that contingent fee lawyer in half. And we send the lawyer half of it down to court to litigate the case and report back on how it's going and how it turned out. And we replace the financier half of that lawyer with a professional funder who pays the bills and bears the ultimate risk of loss on the case. Of course, there are differences between us and a contingent fee lawyer, many differences. We don't practice law, for one, obviously. But in terms of the structure of the financing, for example, a typical contingent fee arrangement, of course, is structured as a percentage of the ultimate gross recovery. The lawyer takes 25 or 33% or more of the judgment or settlement, or takes percentages on a sliding scale depending on the timeline and so forth. Whereas our financings are often structured instead by reference to a multiple of our investment in pursuing the case rather than a percentage of the recovery. But of course, both contingent fee lawyers and litigation financiers have essentially an infinite number of ways to structure the financing of the case. So we're just talking very generally here.
Is there any typical or standard way, Andy, that you do these financings, a typical deal?
Yeah, I can give you an example and we can sort of work through it. But I'd stress that particularly at the upper end of legal finance, where we're talking about 8 to 9 to 10 figure amounts of dispute, it's a very bespoke business. So rarely do any two deals have exactly the same structure, but I can give you an idea of the parameters involved. So let's suppose that our old friend from law school, ABC Corporation, has a breach of contract case that it wants to bring against its trading partner, XYZ Corporation. ABC wants to hire Mega Law, which is an AmLaw 10 firm that it usually uses as its outside counsel, wants to hire Mega Law to bring this case. And the case is going to be costing about $10 million from filing to verdict. Now, in this case, ABC is, because of XYZ's breach, ABC isn't bringing in any current revenue, so it can't afford Mega Law's hourly rates, which are lofty. And Mega Law, on its part, doesn't want to take the case on a contingency. It's not because it doesn't like the case, but it's just not interested in being a risk-taking entity. So the best Mega Law will offer may be, say, a 20% discount, maybe with the recoupment of the discount, or even a premium if the case is a winner. But basically, the lion's share of that legal bill is looking for somebody to pay it, and the client can't pay it, and the law firm doesn't want to take the risk on it. So a litigation funder arrives on the scene and does its diligence. And if the funder likes the case and likes the budget, it might agree to pay Mega Law's discounted bills for fees and costs as incurred up to that full $10 million budget. And a typical structure for the funder's return might be that out of the proceeds of the case only, the funder gets back the amount it's deployed under the financing, the $10 million, plus possibly single-digit multiplier of that investment, and or a percentage of the gross recovery, and or some interest-like component based on the time the case takes to resolve. And whether it's one or two or all three of those structures, or a combination of them, as I say, is very much, there's a lot of flexibility in that. But that's generally the notion is the funder deploys X dollars and gets back its X dollars plus a premium referring to either the what X is, or some other variable.
So let's talk about the handicapping or underwriting of the cases. There must be a tremendous due diligence process that goes in before you invest sums of those magnitudes. How does the underwriting or handicapping of the cases or groups of cases work? Does it differ from what a contingent fee lawyer does?
The answer is yes and no. I think it's certainly a funder's diligence process looks to many, if not all, of the same variables a contingent fee lawyer's diligence or evaluation process does, but it probably looks at them in a different way and a different level of detail. I can't talk about any of the modeling or analytics that Burford uses. Obviously, that's our secret sauce that we think sets us apart from other companies in our space. But speaking very generally, I think what commercial funders do is a bit more sophisticated and data-driven look at the same parameters a lawyer, contingent fee lawyer, or a client considering filing a lawsuit and funding it itself would look at. The legal merits, how solid a case is this? The process risks, what law will apply, what court are we going to be in, what judge is going to hear the case. If it's already filed, you know that. If it isn't, you don't. What's the jury pool like in the likely jurisdiction? The duration risk, how long it's going to be until the funder sees a return on its investment. That's a very important variable given how long some commercial lawsuits and arbitrations can last these days. The credit risk, both of our counterparty and of the opposing party. We want our counterparty, the party that we're financing, to more likely be still with us at the end of the case, rather than being a bankruptcy estate where we find ourselves, in a room full of creditors competing for the leftovers. And by the same token, we look at the credit worthiness of the opposing party in the litigation we're going to finance, because we don't want to get a $500 million judgment against somebody who can't pay it. So a lot of diligence goes into the credit risk of the transaction. We look at the resources and the motivations of the opposing party. Is this going to be a case against a sort of a rational economic actor, or is there some animus or some history or some corporate personality of the defendant that leads us to think it's going to really be orienting itself towards delay and inflicting a lot of additional expense. And we look at the quality of the lawyers on both sides of the case. We invest in cases that are brought by lawyers that we are confident can win them, and we evaluate the cut of the jib of the lawyers on the other side to see if we can gain any optimism or pessimism about how easy or hard it's going to be to win the case. So that's kind of the laundry list of issues we look at. And there's of course 1,000,001 unique features of every case that may come into play.
So Andy, let's talk about how it plays out in the mediation process. And first, I want to ask, you deal in 8, 9, 10-figure cases, which are wonderful cases to mediate, but let's face it, there's not all that many of them. Is it possible that litigation funding could be at play in smaller stakes cases if they're potentially part of a portfolio like mass torts, pharmaceuticals, things of that nature? Perhaps not by Burford, but by other funders?
The litigation finance business is, as many businesses are, as the legal business is segmented. So there's a sort of a top tier that deals with large commercial cases with AmLaw 100 law firms on both sides much of the time, and a lot of bet the company exposure, bet the product exposure, or what have you. Then there's what most of us call the middle market, which is cases that may be in the 6 to 7 figure range, worth fighting about with good lawyers, but not necessarily ones that can support the the level of infrastructure that a Burford or one of its peers would support. And then there's a booming business in what's called consumer legal finance, where if you got a $40,000 or $50,000 beef with a small business, or you have a personal injury case that's worth six figures. There's plenty of activity in that space where a claimant can find support for their case. And at the lower ends, of course, it's much more of a kind of a form transaction. There's much less bespoke underwriting and structuring.
Let's talk about how this plays out in mediation, because litigation funding, litigation finance could be anywhere. From the standpoint of parties coming to a mediation, does it change the mediation process much, if at all? And if it changes the mediation process, how do you think it does so?
Well, as a general proposition, I don't think it changes the litigation dynamics or the settlement dynamics. Of course, every case is different in terms of the economic, both the plaintiff and its lawyers and the defendant and its lawyers are dealing with. Some plaintiffs and some lawyers and some defendants have a lot of cash, some have none. A number of the ways, both contingent fee agreements and litigation finance agreements can be structured is infinite. So the dynamics are really all over the map. But the bottom line, I think, is that as with the involvement of contingent fee lawyers themselves, the involvement of litigation funders just means the plaintiffs and possibly their lawyers have access to more resources than they would otherwise. And so assumptions about a plaintiff's ability to continue the fight and continue to prosecute the case, the judgment, are may be subject to a little more uncertainty than they were before litigation funders arrived. But that uncertainty has always been there and will always be there.
So if a defendant is curious as to whether litigation funding is behind the scenes, how can they find out? Well,
generally they can't. With few exceptions, courts hold that litigation financing and litigation financing agreements just aren't relevant and so aren't discoverable. They don't bear on the resolution of any material issues in the case, and therefore they're held to be generally not discoverable.
When would you want to keep it a secret?
Probably the principal one is just to avoid the kind of discovery and motion practice sideshows that can develop when a party decides that he wants to complicate and delay things for tactical reasons, or thinks it can somehow figure out a way to make hay out of the fact that a funder is interested in the case. We really don't like the financing of a case to become part of the case when it doesn't have any relevance to it. Among other reasons, that just makes the case more expensive. If we're paying the bills for it, we don't want to engage in a sort of a sideshow about our involvement in the case in the sense that we are providing financing for it. And the courts have agreed many times that, again, financing just isn't relevant to anything in most cases. So it's really just to keep financing just from becoming an expensive distraction.
Now that we've resolved that one, let's take up another one on tipping your hand or reading between the lines. If you take a look at the posts on LinkedIn of some lawyers who are partners in law firms that prosecute patent infringement cases, they tout themselves as being willing to work with litigation funders. And some I know have even moved firms because they wanted to be with firms that were more hospitable to working with litigation funders. So is it sometimes the case that the presence of a particular law firm representing a plaintiff is a way of tipping the hand or acknowledging that a funder is involved, akin to the way that the presence of some firms in the world on the defense side indicate that particular insurance carriers may be involved?
Yeah, it's an interesting question. I guess you could say, all else being equal, maybe would make it a wee bit more likely that a given case was financed if you were dealing with a firm like that. But I don't think it's going to be a very good indicator. The fact that a firm appears in one or more financed cases or regularly uses funding is I think hard to extrapolate into a conclusion that the firm works only or mostly on financed cases, and therefore that any case it files is probably financed. For one thing, a lot of time the party getting the financing is the law firm, it's the client. You don't know just because Mega Law is working on a finance case. If you know that fact, you don't know whether it's the client or the firm that has financed the case. So that's one thing that makes it not a very good proxy. And of course, a firm could be financing a big portfolio of plaintiff side cases, but still be doing most of its work on plaintiff cases by the hour. So there certainly are some firms that I think are known to be financier partners more than others are. But I think it's and on the margins that might make you more suspicious about whether the case that you're litigating against them is financed. But I don't think it's a very good litmus test.
Is it sometimes the case, Andy, that the law firm does not know that the client is using litigation finance?
I think that's unusual, but it can happen.
Okay, so let's talk about disclosure a little more from the perspective of defendants. It's standard practice when a defense is financed by insurance, standard practice for that to be disclosed through court rules, discovery, interrogatories, or whatever. So would not defendants, on the flip side of that coin, sometimes complain that not disclosing the existence of funding on the plaintiff side, or disclosing only its existence but none of the details about it, isn't fair? Because after all, if the insurance coverage has to be disclosed on the defense side, why not the funding arrangement on the plaintiff side?
Yeah, that is certainly a regular subject of debate, and you could spend weeks and months reading counterpoint on that on the web. I think the answer is it's not really unfair, and courts have certainly said this in written opinions. There's a reason for that asymmetry, and I think it goes probably to the biggest misconception people have about litigation finance. The difference between an insurer's role and a litigation funder's role is that in virtually every case in which the insurer covers or potentially covers a defendant's liability, and I was an insurance lawyer, so I'm not making this up, in virtually every covered defense, the insurer has a contractual right to, in one way or another, control whether and on what terms that case can be settled. It may have an express right to settle over the policyholder's objection. It may have the right to consent or hold consent to settlement. It may have a so-called hammer clause that essentially penalizes the policyholder if it refuses to settle. But insurers generally have a great deal of control by contract over whether and on what terms a defendant they insure will settle a case. In contrast, litigation funders don't have the right to control the settlement of cases they finance. They can't insist that the plaintiff settle at a given figure and no lower. They also can't veto the plaintiff's decision to settle at a given figure and not higher. And they don't have control over litigation strategy and tactics either. All of that is that non-control of the funder is normally spelled out very expressly in the financing documents to put both the plaintiffs and their lawyers' minds at ease that they still have complete control over the conduct of the case and settling it. So comparing litigation funders to insurers in terms of the fund they have on the scale is not a good comparison. Insurers are in a completely different part of the universe in that respect.
So is that why litigation funders sometimes don't show up at mediations, even though they may have a tremendous stake in the outcome of the case?
Just like it because in a non-finance case, the plaintiff always has the say over whether and on what terms the case settles or doesn't settle.
So Andy, you're sitting back there, you've got millions of dollars riding on the result. You just say to the plaintiff, you go handle the mediation, give us a call afterwards and let us know how it comes out. How can you be so passive in it?
Yeah, it might seem it's sort of like the litigation equivalent of watching the Super Bowl when you have a $10 million bet down on it, and all you can do is just sit there while the coach plays. It is a risk-taking enterprise. There's no doubt about it. It's not quite that bad, though. The beauty of being able to structure the investment in a case in an infinite number of ways is that you can do a pretty good job with our experience base anyway of anticipating the twists and turns the case might take and how that might affect its value and the plaintiff's feeling about settling the case along the way. And you can build those variables into the cost of capital you're committing and the way that capital commitment is structured. So, I mean, the goal in every case is to structure the financing so the interests of the plaintiff, the party you're funding, and the lawyers and the funder are all aligned all the way down the timeline. So if we do things right, we never get to a point where one party to the financing arrangement really wants to settle and the other party really wants to keep litigating. I mean, that's when that happens, it's unfortunate and can be disappointing to somebody. But as I say, we have tools for structuring things so that things align and the interests are aligned. And I mean, conceptually, that isn't different from what a contingent fee lawyer does when they do a case on a sliding scale, if you think about it. 25% if the case settles early, 33% if a case gets close to trial, and 40% if it goes to verdict. There's a structuring that keeps the contingent fee lawyer's interests aligned with their client, roughly speaking. And it's basically in either enterprise, it's basically about creating a win-win outcome along a spectrum of possible paths the case can take.
Yes, and there are times in the plaintiff's room when, despite all that planning, at the end of the mediation, get down to the point of perhaps asking a contingent fee lawyer whether they would consider reducing their fee somewhat in order to get enough money into the plaintiff's pocket to make a deal. Do those conversations take place at the end of mediations as well? Are there calls to the funder saying, hey, this is the most we can get out of this defendant, seems like a pretty reasonable deal based on what we've learned today? Can we kind of massage things with you guys to make this deal go down? Does that happen?
That does happen occasionally. I mean, litigation financiers aren't stupid. I mean, if there's a favorable settlement to be gained, and just saying no on principle would blow it up, that wouldn't be very smart. So certainly that conversation does happen. I don't want to venture a comment on how often it leads to any alteration in the terms of the financing. But I mean, the whole idea is you got rational economic actors, getting in a relationship with each other, and when that happens, there's always an opportunity to revisit what your terms are. I don't want to give the impression that those terms are revisited frequently, but it has been known to happen.
You guys, with all your hundreds and hundreds of years of litigation experience, the big data that you use, you must have ways of structuring things that make you comfortable with letting the plaintiff and its lawyers drive the bus for so much of the litigation process. Can you tell us more about the way that things commonly get structured so that we have a better understanding of that?
Yeah. I mean, as I say, there are an infinite number of structures out there, but let me and so many variables in structuring them. But let me give you an example. And to keep it simple, let's just talk about kind of one of the levers we have, or one of the tools we have in structuring financing to keep the interests aligned and make for a win-win experience. So let's keep it simple and just talk about what I would call the quantum variable, the relationship between the size of the case, in other words, the amount of damages in issue, and the size of the investment the funder is being asked to make. Funders usually have some rule of thumb about that ratio, because they want to ensure that there's enough room in the financing agreement for the plaintiff to settle the case for less than 100 cents on the dollar and still have a favorable recovery after paying the funder its share. You don't want somebody concluding that, well, we just have to take this case to trial rather than settle it, because that's the only way that we're going to see a dime out of the case after paying the financing expense. That obviously is not a situation that is healthy. So let's work through a little example. Let's suppose that for cases of a certain risk profile, pick a kind of case, an antitrust case or a breach of contract case, whatever. Suppose that for cases in that sort of risk bucket, a funder is looking to get its investment back plus 2 times that investment. That's its target return on cases like that. So in that scenario, the funder is not going to invest $4 million in legal fees in a case that only has, say, $15 million in provable damages. Do the simple math, that case would have to settle for over $12 million before the plaintiff started to recover any net proceeds, right? The funder gets back its $4 million plus a two times multiple of that, so that's 8 for a total of 12. So at a $12 million settlement, the funder has taken 100% of the proceeds and the plaintiff has received nothing. So, in contrast, that funder might happily take that $4 million and put it into a case that's got $50 million in provable damages, because on the same terms, the investment back plus 2 times that investment, the plaintiff would end up with the lion's share of the recovery, even if that case settled for only $25 million or 50 cents on the dollar. The funder, again, would get its $4 million investment back, would get its $8 million premium, but the plaintiff would still walk away with a net of $13 million. So, that's one tool we have among many for structuring the financing in a way that keeps everybody's incentives aligned and leaves hopefully everybody happy with the outcome across a range of outcomes.
But at the same time, you have to make sure that you're putting enough money into the case to make sure that it can be appropriately prosecuted.
Absolutely. And one of the first things that we ask for when we're vetting a case is, what's the budget? What's the budget for fees and expenses through trial? We don't assume that the case is going to settle short of trial. We look at the case and say, what's it going to take to take this case all the way to verdict and judgment, if that's what we have to do. And we spend a great deal of time kicking the tires and playing devil's advocate on the legal budgets, because the legal budget is generally the amount of our commitment. And we, at least at Burford, when we make that commitment to fund a case up to that amount, we do it in the absolute expectation that is going to be our investment in the case, and that we're not going to see somebody run through the $10 million we put down and then come back and ask for another 5. So we spend a lot of time. We have a lot of experience since most of our underwriters, big law vets. We know what legal bills look like. We know what they're made up of. We know how they can be reduced, how they can be increased. We spend a great deal of time picking apart legal budgets and adjusting, the amount of the investment requested to be realistic, so that we don't find ourselves in that situation where the kettle is boiled dry before the tea is made.
Are there other ways that you all help litigants, help plaintiffs share or transfer legal risks?
I'd say besides financing legal expense in pursuing litigation, I'd say the other principal thing we do is monetize. It's basically monetize claims. That is to underwrite the risk the litigant won't end up with any recovery after it has pursued a case to a conclusion. We call that monetizing the claim. We'll pay a claimant, the would-be or current plaintiff, a sum of money which it's entitled to use as it sees fit. If it's not financing the legal spend, it can pay its lawyers with the money. If it's just, if it's got a contingent fee deal with the lawyers already, but it wants some cash in hand to go spend on R&D or marketing or building a new plant or something like that, it can use the money to do that. We will pay it a lump sum at the point we enter the case, which may be at the beginning of the case, or it may be somewhere in the course of the proceedings. And as with legal expenses we finance, we'll recover that money plus our premium if and when the case eventually produces proceeds. Or if we're working with a law firm that's working on a contingent basis, we'll pay the law firm a lump sum up front and get our recovery out of the fee that it ultimately receives for that case when it resolves. So the contingent lawyer has a 33% interest in a case that is not going to resolve for 3 or 4 years. We may monetize, but we'll then get 33% of whatever the recovery is. We will monetize a portion of that 33% recovery today, and the lawyer can go invest in some new cases or buy a beach house or pay the associates or what have you.
Well, when you monetize the claim and give the plaintiff itself a sum of money, you expect that plaintiff to use the money to litigate the case, right?
Well, not necessarily. I mean, there's no law that says you have that only impecunious litigants monetize their claims. Sometimes, a well-heeled company may be looking at $100 million recovery, but it's 4 years down the line, and they may say, well, looking at the capital markets, we think the best money deal we can get today is to monetize a portion of that recovery with a litigation funder rather than issuing a note or calling down our bank line or whatever. That's the most favorable terms on which we can get some money today on the claim that will pay off 5 years from now.
Still, you want some assurance the claim is actually prosecuted, I would assume.
Oh, well, absolutely. And I mean, they're essentially we do the same diligence, and we require the same diligence on the part of the plaintiff in pursuing the case. And again, it's all about aligning terms. If we have purchased the entire claim, which we occasionally do, but is not our principal activity, and actually buy the chosen action, that's a separate kind of transaction. But if we're monetizing a portion of someone's recovery, say they think they're going to hit $500 million on an antitrust case, and we're monetizing $75 million of it today, ideally there's enough headroom in there, again, that they will have all the incentive they need to continue pursuing the case, because they will keep the rest of the upside that they didn't monetize with us at the end of the case. If we're concerned about that, then we have to start looking at other levers we can pull to make sure that the incentives are aligned, because obviously we don't want somebody carrying our water who doesn't want to carry water.
So in those cases, you try to ensure that the plaintiff still has the incentive in litigating or coming to a mediation, still has the incentive to fight hard and fight fair and maximize its recovery for the benefit of everybody.
We never want our counterparty to not be excited at the prospect of recovering on its claim. And as I say, we spend a great deal of effort structuring the financing to make sure that it is always excited about the prospect of getting more rather than less on that claim.
So when do people do this, Andy? Do they come to you before a lawsuit is filed? Do they come to you with a proposed complaint? Do they come to you right before they have to pay tons of money to experts for discovery? preparation of reports. What's the timing of it all?
Litigation financiers fund cases all along the timeline from before they're ever filed to when they are on appeal, and even when they're in the Supreme Court of the United States, if it comes to that. There are, as long as there is legal risk in the equation, there is legal risk that can be shifted and financed. So we are approached about financing cases all along the spectrum. Many cases before they're filed. Of course, people are saying, I've got a good case here. My lawyers tell me it's great, but before I commit to, filing the case, I need to know who's going to pay for this. But very regularly we get inquiries about cases that have been filed and have survived a motion to dismiss, for example. That's an important milestone in the life of many cases, and a case that we might not be interested in financing pre-filing because we have questions about the court's willingness to let it proceed may be answered by a ruling on a motion to dismiss. And we have financed many cases that we initially declined, after taking a second look at them as they moved through the process a little bit. A party may come to us after they have defeated the defendant's summary judgment motion and say, the court's given me a license to try this case. And of course, that, generally speaking, may significantly alter the settlement value of that case and the settlement dynamic, and we may be interested in financing a case at that stage. And of course, as you go down the timeline and these milestones are passed, the good news for the plaintiff is since the number of variables in the mix is decreasing, and the number of uncertainties and the number of ways they can lose the case is being reduced, the risk is decreasing, and that may mean that the capital to continue the fight is available on cheaper terms because the risk is lower. And just to finish the thought, we will often finance cases after a verdict, somebody just says, well, I just won a $60 million judgment. The defendant's now telling me that they're going to dance me around in the Court of Appeal for the next 4 years. And I got to hire the best appellate lawyers to go all the way to the United States Supreme Court if necessary. So finance that, and or will you monetize my judgment, please? And we are always excited to look at propositions like that, which again have a lot of the riskiness baked out of them at that point on the litigation timeline.
So let's talk about some of the criticisms you read regarding litigation funding. There are people who say that there's a dark side to making capital available in this way because it encourages the pursuit of opportunistic claims by people who don't have much to lose. What about that?
And the answer sort of lies in the fact that the premise of that question is I think obviously false. You talk about a case where somebody has nothing to lose. Well, there aren't many cases like that in the world. If the plaintiff is paying a lawyer to file it, then by definition the plaintiff has something to lose. If a contingent fee lawyer is taking the case and not going to get paid unless there's a recovery, the contingent fee lawyer has something to lose. And if a financier is financing the case, then obviously it has something to lose. So it's a bit of a false query. But more generally speaking, the notion that the availability of litigation finance somehow promotes the filing of meritless claims, I think is really pretty baseless. If you showed me a legal financier who invests in cases that it thinks are going to lose or are pretty likely to lose, then I'll show you somebody who's going to be in business for about 10 minutes and isn't going to have much luck raising any capital to invest. Nobody who is a sane person, no economic actor acting rationally, is going to invest in propositions that it honestly thinks are losers. And indeed, if anything, legal finance adds a layer of quality assurance that a system with only plaintiffs and lawyers in it doesn't have. Think about it, getting a professional investor to add a layer of review to a case before it's filed or before it's pursued further is one way to discourage people from investing money in cases that are weak. So it's just I think a false a straw man argument where there's not even a straw man there. Litigation finance, to the extent that it's tarred as using other people's money to prosecute meritless claims they don't have the guts to prosecute themselves. I mean, that's what contingent fee lawyering is. And the only difference is that as I said earlier, we sort of decoupled or split the lawyering part from the financing part of what the classic contingent fee lawyer does. Nobody's seriously, anyway, calling for the abolition of contingent fee lawyering on the ground that it gives plaintiffs nothing to lose when they sue. We trust that when lawyers file cases, at least lawyers who want to make a living at it and not just cause trouble, we trust those lawyers to vet cases before you invest in them. And why wouldn't you trust other lawyers who can raise capital and vet cases to do the same thing before they invest the public's or their shareholders' money? So I do think that's kind of an easy critique to me.
Andy, this is really a fascinating to what litigation funding is and what it isn't. Before we conclude this part of the interview and open it up to questions and answers from our audience, do you have any parting thoughts for mediators in particular, as well as lawyers and parties participating in mediation? How can and should we adapt the growing role of litigation funding in the litigation process?
Yeah, well, let me give you a handful, or maybe a part of a second hand, also full of takeaways from this discussion. First, don't assume that the plaintiff or the plaintiff's lawyer can be out-resourced. Neither the lawyer or the plaintiff themselves may be taking risk or a major portion of the risk on the case. So be wary of making that assumption. Likewise, don't assume that you can accurately assess the plaintiff's or its lawyer's sensitivity to spending cash on lawyers or on its legal spend hitting its bottom line. No matter what the papers and their SEC filings say about a party or their lawyer's financial situation and prospects, they may not have any sensitivity like that because it's not their cash being spent to prosecute the case. Third, don't assume you can drive a wedge between the plaintiff and their lawyer by economic means. Their cost sensitivity and their risk tolerance may be even more closely aligned than it usually is if there's a litigation financer mix. Fourth, don't waste your time in mediation arguing about whether there's a funder involved behind the scenes, and if so, whether they should be present at the mediation. They shouldn't, they don't need to be, and they won't be. Next, if you think the plaintiff is financed, don't assume you can figure out how the funding might be altering their settlement goals or strategy. And that's because there's no, as we talked about, there's no one standard deal structure to a litigation financing. You're never going to be able to guess whether or how financing might play into a plaintiff's willingness to settle at a particular number at a particular time. So don't waste your time trying to figure that out. And finally, remember, as we were just discussing, legal finance can enter the picture at any point along the case timeline, from before the case was filed to while it's pending, and while it's on appeal, and while a cert petition is pending, and beyond even. So don't assume that a case that could have settled for X dollars in the middle of discovery last year is settlable for X dollars a year or two later, because the plaintiff may have gained some staying power it didn't have before. In short, question the assumptions you have traditionally made when you go into a mediation about what the plaintiff's and its lawyer's financial condition are, and reevaluate them based upon what we've discussed here today.
Fascinating stuff. Thank you very much, Andy Lundberg. Now let's take it to live Q&A.